I'm Siobhan Jeffels, a legal director in a family team at Clarion, and today myself and Bronwyn Warmington, an associate solicitor in the team, are discussing the new no-fault divorce procedure, which came into force on the 6th of April this year. So the old divorce regime had been in force for almost 50 years. So the reasons for the changes now are obvious. Divorce and the negotiations over arrangements for children and the separation of financial ties is perhaps the most emotionally charged area of law. The approach of practitioners and the court in this field has evolved enormously over the past 50 years, and we now aim to work in a conciliatory way to help our clients achieve the best outcomes they can with as little hostility as possible. So starting that process of a divorce based on fault and blame did not start the process off on the right foot. Previously, there was only one ground for divorce, the irretrievable breakdown of a marriage, but that was evidenced by one of 5 facts, which were adultery, unreasonable behaviour, desertion, 2-year separation with the other party's consent, or 5-year separation without the other party's consent. The same applies to civil partnerships too, save for the fact of adultery. The blame elements of adultery and reasonable behaviour meant that the applicant either had to show a sexual relationship with a member of the opposite sex, or at least 4 or 5 examples of unreasonable behaviour that the ordinary everyday man or woman in the street would have found unreasonable. So both an objective and subjective element to the test. Assuming that the divorce was undefended, or if defended, the court is satisfied of the allegations, decree nisi would then have been pronounced, and 6 weeks and 1 day later, the petitioner could apply for decree absolute. So why the need for a change? In the 2018 case of Owens and Owens, it was highlighted the inappropriate and outdated state of the law. Notwithstanding that it was abundantly clear the marriage had broken down, Mr. Owens succeeded in successfully defending the divorce, which left the parties still married until Mrs. Owens could petition on the basis of 5 years separation. It's hard enough when a marriage breaks down without having to blame the other party. Drafting the petition was always a balancing act between persuading the court the marriage had broken down, but it not being too strong that the other side would react badly. We often had clients waiting for 2 years from the date of separation to be able to issue a petition that wasn't based on blame. But this had issues. For example, the other party may then withdraw their consent, or because we could not get a financial agreement approved by the court or a pension sharing order made until the divorce had been concluded with the decree absolute being made.
Thanks, Siobhan. Yes, the new regime was definitely welcomed and certainly a long time coming. As you can see from this slide, the new regime retains the only ground for divorce being the irretrievable breakdown of the marriage, but it no longer has to be evidenced by one of the 5 facts. Instead, we simply need to state the marriage has broken down, which is far more conciliatory and amicable. The next point to note is the change in terminology, which will take some getting used to for us all. As you can see from this slide, a petition and the petitioner now becomes the application and the applicant. The decree nisi is now a conditional divorce order, and the decree absolute is a final divorce order. The next slide, I will talk to you about the process. The process is still quite similar. The forms have been updated to reflect the new rules and the different ways the matters will be approached, but there's now significant differences to a degree. So for the first time, a joint application can be issued. Again, this makes matters much more amicable, and if people do go down this route, then the parties would be known as applicant 1 and applicant 2, as opposed to the applicant and the respondent. In the less amicable cases, or those where the other party may not cooperate, there can still be a sole application where the applicant would be known as a sole applicant and the other party would be known as a respondent. The next stage is the acknowledgement of service. In a sole application, the respondent will be served with notice of the proceedings, and in a joint application, both parties will be served. The acknowledgement of service by the respondent must be given within 14 days of service. The divorce can then be progressed. If there's some cases where a respondent is failing to respond or cooperate, it can be progressed in the respondent's absence in some circumstances. In these situations, we have to have clear proof that they've received the divorce papers. So if there's no email or messages or letter confirmation suggesting this is the case, we can arrange for a process server to serve them directly with the papers, and the court will then take the process server's certificate of service as proof of receipt, and the divorce will be able to progress in absence of full cooperation. This happens in very rare cases, but it's really useful that this can be progressed in this way. In terms of disputing the application, the ability to defend a divorce has been removed, except in a limited number of issues, none of which relate to the actual breakdown of the marriage. So the circumstances where a divorce can be defended are where the jurisdiction is disputed, the validity of the marriage or civil partnership is disputed, and where the marriage or civil partnership has already been legally ended. So the court will not expect the parties to remain married if one party wants a divorce, even if the other doesn't. The conditional order is the next stage, and this cannot be applied for until 20 weeks after issue of the application. Previously, you could apply for decree nisi straight after an acknowledgement of service was filed, so this change potentially delays the process significantly. The intention behind the 20-week period is for both parties to have a reflection period to determine how they wish to proceed and whether or not they wish to reconcile. In reality, it is very rare that parties decide to reconcile and withdraw their application once a process is underway, but the reflection period gives them some time to decide on this. The final order is the final stage in the divorce, and a final order cannot be applied for until 6 weeks and 1 day after the pronouncement of the conditional order. We often advise in most of our cases to not make the divorce final until a financial order has been made by the court due to a range of reasons. For example, potential loss of spousal capital gains exemptions for asset transfers, or potential losses of pension rights on divorce. The final order is then granted and the implementation of the financial order can commence.
So one of the changes under the new regime is the approach to claiming costs in the divorce. So the ability to pursue costs has changed, as previously in the petition, a party could claim for their legal costs and for the court fee, which is £593 from the court, and the court would then decide that if the parties could not agree. However, under the new regime, there's no automatic ability to seek costs, and a separate application and additional court fee would need to be paid in order to pursue a claim for costs for a divorce. In a disputed divorce, the court may make a costs order against the unsuccessful party in the same manner as they did do previously. However, as a whole purpose of the new procedure is to remove fault-based divorces, it seems difficult to envisage a situation where a costs order would be made if it is an issue that is going to have to be addressed and agreed at the outset on any joint or sole applications. This might have some practical issues, so we'll have to keep an eye on this point and see if the procedure evolves over time. So where does this leave us now? There are undoubted advantages to the new procedure. It reduces conflict and enables parties to work together in the divorce process in the same way that they are encouraged to do so regarding the arrangements for their children and the finances on separation. The new imposition of a minimum 20-week period before the conditional order can be obtained, and an overall timescale of 26 weeks to a final order, does lengthen the overall process under the new regime. The disadvantage of this is that if the parties have been able to agree the terms of their financial settlement, no court order can be approved by a judge before 20 weeks after the issue of the divorce application, and it won't be enforceable for at least 26 weeks when the final divorce order is made. If such an agreement includes a pension sharing order, there is the potential for a significant period of time to pass between the date when the agreement was reached and the date when the pension sharing order will be implemented. This could undermine the intention behind the agreement, as the value of the pension may change during this time, potentially quite significantly. This is a real concern, as we have to express the amount of a pension sharing order as a percentage of a pension pot in the financial agreement. Therefore, if it takes 26 weeks after agreeing the percentage to be transferred, the amount being transferred may not be what the other party intended, especially if the pension has changed in value, either being increasing in value or indeed decreasing. These are matters that need to be kept in mind for all practitioners when advising on the timing of the issue of a divorce application and agreeing the terms of the financial settlement. Thank you.
Thank you.